Hello, mic check. 19. ಅಮರಣ್ಣವ್ರು ತಾನೆ ಜಡ್ಜ್ ಅಲ್ಲಿ ಇವಾಗ ಇದೊಂದು ಡೇಟದ ಪ್ರಿಂಟ್. ಡ್ರಾಪ್ ಮಾಡ್ಕೊಂಡು ಹುಡ್ಕೊ ಬರ್ತಾರೆ. ಗೌರ್ಮೆಂಟ್ ಅವ್ರು ಯಾರಿಗೂ ಬಂದಿಲ್ಲ. ಅಂದ್ರ any memos? Yes. Yes. For final hearing. Appeal is already admitted. Appeal is already admitted. Whether appeal is already admitted. ನಾನೊಂದು ಹೇಳಿದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. Then argue on merits. Final hearing. Be ready to address the arguments. Final hearing. Yes. Next.
Any adjournment? List 1, page 3, serial number 15. Page 4, serial number 16 to 19. Page 5, serial number 20 to 22.
Serial number? Noted. Amen. Barley.
List 1, page 1, serial number 1, non-compliance of office objection for first time. C. Parmeshwarappa.
Absent no reproach. Learned counsel for the appellant is absent no representation. List of compliance of office objections.
Non-compliance for second time, serial number 2, B.D. Krishnegowda.
Same.
Serial number 3, Shenshi Ali.
ಏನಾಗಿದೆ ಕಂಪ್ಲೈಂಟ್ ಯು ಆರ್ ಪ್ರೇಯಿಂಗ್ ಫಾರ್ ಟೈಮ್ ಅದನ್ನು ಹೇಳಬೇಕಲ್ವಾ ಏನು ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಪ್ರೇಸ್ ಫಾರ್ ಟೈಮ್
Non-compliance for third time, serial number 4, B.S. Manjunath.
ಏನು ಇಟ್ಸ್ 2023 ನಾ No, why this 2023 appeal is pending? Yes. Yes.
Therefore, we find an appeal.
But why 23? Still you have not complied with.
No, this basic objection is that here now they are objecting, the appeal is not sincere.
ಯಾವುದು objection under ಯಾಕಂದ್ರೆ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದು No, your application A1 of 2023 is not maintainable. How it is maintainable? What is to be stayed? No, not regarding the maintainability of appeal. Very simple thing. Since 2 years it is pending. IA1 of 2023 seeking stay is not maintainable. The objections raised by the office is repelled. IA is dismissed as not maintainable. Then other objections are. Still there are 4 more objections. Pass over. Please first understand what is the objection. Otherwise another 2 years will lapse. Please understand the objections and comply with them. Next.
For order, serial number 5, Vijayalakshmi R.
Counsel for the appellant is absent, no representation. Yes, next.
Serial number 6, Ajit PB. Awaiting notice.
Saroda. Hoda. Yes, already served alla ಮತ್ತೆ okay. As per the police report, it is served. Tell the police report. ಅದು ಏನೋ ಇದು ವಾಟ್ಸಪ್ ಏನೋ ಕಳಿಸಿದರೆ ಸರ್ವ್ಡ್ ಅಂತ ಇದ್ದಾರೆ. Let them go. Let them go. What is the relief you are claiming? What is the relief you are claiming? CC number so and so. On merits, it will be decided. How many days it may take? Let them travel. Why should I permit? Seek permission from your higher officer. Why the permission of the court is necessary? Let them go. If they are permitted, let them go. Learned additional SPP pays for time. On the ground that a police person is deputed to serve the notice of the petition on respondent number 2 personally. As per order dated so and so, notice of the petition was served on respondent number 2 through WhatsApp. However, the investigating officer is permitted to serve the notice on respondent number 2 personally. Next, learned counsel for the petitioner prays for time. This time. After 2 weeks. Next. Report? ಅದು ತಗೊಳ್ಳಿ, ಫೈಲ್ ಡೇ ರಿಪೋರ್ಟ್ ಅಂತ ತಗೊಳ್ಳಿ. ಅದರಲ್ಲಿ ಏನಿದೆ ನೋಡ್ಕೊಳ್ಳಿ, ಸೇಮ್ ಇದ್ರೆ ಆಯ್ತು. ಎಸ್.
Hearing on IA, serial number 7, A. Radhakrishna.
counsel for the appellant filed a memo seeking permission to withdraw the appeal. Memo is placed on record, appeal is dismissed as withdrawn. In view of dismissal of the appeal, IA 1 of 2024 stands disposed of. Yes.
Serial number 8, Vikram Raj, MB Ravi Kumar.
In total, he's in custody for the past 5
Is
years.
stated in the judgment.
Yes, Your Lordships.
Where?
Order on sentence, Your Lordships.
Order of
At,
sentence alla.
Adರಲ್ಲಿ,
It was on bail ಅನ್ನೋದು ಎಲ್ಲಿ?
there is a mention of that averment in
Which paragraph?
page number 19 of the judgment, Your Lordships, page number 30 of the appeal.
Page number?
Page number 30 of the
Yes.
appeal, Your Lordships. Intra page number 19 of the judgment. Set off for the period from 6 November 2019, that is date of arrest, till 20 July 2022. So that was the date of release. And thereafter, after he was convicted, a conviction warrant was issued, Your Lordships.
Now you are convicted for?
Section 6 of POCSO for 15 years, Your Lordships, 506 of IPC for 6 months.
So you are in custody from November 2019 to July 2022.
That was the first time that was the bail was filed, Your Lordships, during the trial.
Almost during trial you are in bail. You are not on bail.
The reason why the accused was not on bail is, Your Lordships, that was the first time he had filed for bail applications.
And moreover, criminal appeal.
Accused number 2 has been acquitted, Your Lordships.
Criminal appeal is of the year 2023.
Yes, Your
What you are doing all these years?
20
It was come up today now.
Order on sentence.
2 years.
Service was difficult, Your Lordships. Service to the respondent number 2.
Yes, what do you say? ಅಲ್ಲ ಮೆರಿಟ್ಸ್ ಅಲ್ಲ ಇದ್ರ ಮೇಲೆ. He was on bail. ಅಷ್ಟೇ heard alone additional SPP on IA 2 of 2023 seeking suspension of sentence and releasing the appellant on bail. Even though serious allegations are made against the appellant and he is convicted for the offense punishable under section so and so, sentencing him to undergo so and so, pay a fine of rupees so and so. The fact remains that the appellant was on bail during trial. He was taken to custody on the date of conviction, and since then he is in judicial custody. Nothing is placed on record to contend that the appellant has been misused his liberty granted during trial. It is also not the contention of the prosecution that the appellant is having criminal antecedents. Considering all these facts and circumstances, I am not opinion. I allowed subject to conditions.
Grateful, Your Lordships.
Serial number 9, Tigri Veeranna.
Actually, earlier we have filed the appeal minutes, actually.
Your appeal is ಯಾವುದು? It is not listed today.
Not listed minutes. It's still in the FR.
ಅದು ನೀವೇ ಸೆಟಲ್ ಮಾಡ್ಬೇಕು, ನಾನು ಸೆಟಲ್ ಮಾಡಲ್ಲ. ಅದು ಆಯ್ತು, ಬೋತ್ ಆಫ್ ಯು ಶುಡ್ ಸೆಟಲ್. ಇಲ್ಲಾಂದ್ರೆ ಎರಡು ಅಪೀಲ್ ಅನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. ಯಾವ್ದು ನಂಬರ್?
Take the instructions of the accused.
It is stated that another criminal appeal in criminal appeal number so and so was filed by the appellant Hence, office is directed to list both the appeals together to pass necessary orders. This time, yes. Both the appeals will be listed.
Please.
In the meantime, you have to decide which appeal should survive. Yes.
Serial number 10.
Appearing for the petitioner, my lord, we have filed application for the recall of order dated 6/6/2025. In the last year,
No, I will not recall.
my lord, in the last hearing date, we met with an accident, my lord. For that reason, we could not come before this honorable court.
No.
And we have, my lord, we have
Putting the-
attached the copy of the complaint, my lord. Can, it is a NCR that on that day we filed, we have lodged a complaint also before the jurisdictional police, my lord.
Who is Nanda Kumar?
Nanda Kumar is my senior, my lord. We were traveling, we were on the way to come to this honorable, to come before this honorable court. On the day we met with an accident, my lord.
What time?
10:15, my lord. In the morning session only. Fully our vehicle got damaged. For that reason, we had to take the injured person to the hospital. Thereafter,
Was injured?
the opposite vehicle who was,
Dashed to him.
yes, my lord. In the Serpentine Road, which
You
is
filed
near.
the complaint.
Yes, my lord. And we gave the vehicle to the insurance.
Yourself caused the accident and filed the complaint.
No, no, my lord. The opposite person who was coming opposite to our vehicle, he dashed it. And he got injured it. We were traveling by car, my lord. For that reason, we could not come before this honorable court on time, my lord. Then, after verifying it, we came to know that the court dismissed it.
Have you mentioned the time of accident?
Yes, my lord. 10:15, my lord.
Where is it?
$13.45 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸುಮ್ಮನೆ.
Means,
We gave complaint after coming, after attending another case.
I know that.
Yes, my lord.
I am asking you at what time the accident
10:15,
occurred?
my lord.
Where it is
10:15.
stated?
My lord,
Where it is stated?
we have not mentioned the time, but it accident took
Don't
place,
know
my
the
lord.
vehicle number, you
My
don't
lord.
know the person, you don't know
My
the
lord,
time.
for that reason,
and I
even we
have
will
to show this
submit the
application.
insurance policy that we have taken it, and we.
Next.
Serial number 11. DS Manjunath.
My lord, the impugned order, the fine amount is 30 lakhs, but in the order it has come as 3 lakhs.
Okay, 3 lakhs. $30 lakhs. correct. Only that is to be corrected, is it?
In fact, our specific, the entire payment is made, only 12 lakhs, 12,754 is pending. 50% of that will be 6 lakhs. That's amount to be mentioned.
Condition ಹಾಕಿದ್ದೀನಿ. If you have already complied with, it is well and good.
No, no, we have to deposit 6 lakhs, my lord.
Deposit,
The permission may be required for that.
permission. Okay.
Allah, 3 lakhs in the oil.
Then that will be corrected. That will be pay fine of rupees 30
That will
lakhs.
comply, my lord. The
Yes.
moment-
ಅದನ್ನ ತಗೊಳ್ಳಿ. Hurdle and counsel for the appellant. Appellant and the petitioner and respondent. Huh?
Judgment says 25 lakhs. So the depositing.
No.
The judgment is at page number 26, the operative portion.
ಎಲ್ಲಿಂದ ರೀ ಅವ್ರಿಗೆ 3 lakh ಎಲ್ಲಿಂದ ಬಂತಾರೆ? 29 lakh. 90,000. Fine amount, 30 lakhs as per the judgment.
That's the CC judgment.
Hmm.
Thereafter in appeal, my lord, it was reduced to 25 lakhs.
Criminal appeal.
Criminal, 820,
1 minute,
824%.
1 minute. 25 lakhs.
2510, and thereafter the amount, the payment shown is
It is on merits, my lord. Merits as in-
Payments at present we are not concerned, sir.
yes, my lord, 40 lakhs
Regard to
95,000.
the 25 lakhs.
For 40 lakhs 95,000 we have paid.
Other I will consider.
The balance amount to be paid is 12 lakhs 12,000 754.
Also challenge the order of the criminal appeal by another criminal petition. That may also be tagged along.
Now it will be corrected. 3 lakhs into 25 lakhs. First, per learned counsel for the appellant and respondent. It is noticed that the accused was convicted for the offence punishable under section 138 of NI, and he was sentenced to pay fine of rupees 30 lakhs by the trial court. When the said judgment was challenged before the appellate court in criminal appeal number 832 of 2023, the appeal was partly allowed. And the order of modifying the order of sentence, the accused was sentenced to pay fine of rupees 25.10 lakhs with the default sentence. However, while passing the order on IA-1 of 2023 on 13/10/2023, a mistake was crept in the order to state that the accused is convicted for the offence punishable under section 138 of NI and is sentenced to pay fine of rupees 3 lakh instead of stating rupees 25 lakhs. The office is directed to make necessary corrections in the order. Yes, next stage.
Filed a criminal revision petition 1650 of 23. Same may be tagged along.
Learned counsel for the respondent submits that he has filed criminal revision petition
Petition 1652 of 2020.
so and so out of the same impugned judgment. Office is directed to list both these cases together. ಅದು ಯಾರು ಮಾಡಿದ್ದಾರೆ? Yes. Yes. And place before the appropriate bench. Next.
For further hearing, serial number 12, Vishwanath Shinde, P. Prasanna Kumar.
But I have one submission. When I got the paper book just now, my lord, ಅದು additional copy ಇಲ್ಲ code copy ತಗೊಂಡಿದ್ದೇನೆ. If he concludes, I may be not permitted to reply tomorrow.
Last time ಅದನ್ನೇ ಹೇಳಿದ್ದೀನಿ.
ಅಲ್ಲ ಇವಾಗ ಕೋರ್ಟ್ ತಗೊಂಡು ಅಲ್ಲಿ ಆಫೀಸಲ್ಲಿ ಸಿಗ್ಲಿಲ್ಲ ಕೆಳಗಡೆ. ಐ ರಿಕ್ವೆಸ್ಟೆಡ್ ದ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಟೇಕನ್ ನಾಟ್.
ಆಫೀಸ್ ನಲ್ಲಿ ಇರೋದೇ ಮೇಲ್ ಬರೋದು.
ಆಫೀಸಲ್ಲಿ ಇಲ್ಲ, ಅದು ಒಂದೇ ಕಾಪಿ ಇದೆ. But I am ready not in 22 not I had started not serial number 22.
I'm also same submission.
No, serial number 22 your lordship.
Matter but not ready in this case.
But 22 your lordship had directed me to mention not in the morning itself, you know. This is a case where not Shoka's notice has been issued, not asking you why you should not be dismissed from service. At mention ಮಾಡು ಅಂತ ಹೇಳಿದ್ರೆ ಸಿನಾಪ್ಸಿಸ್ ಕೂಡ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದರಲ್ಲ ನಾಗಲೇ. If your lordship permits me, not this 22 not can I go. So mention ಮಾಡು ಅಂತ ಹೇಳಿದ್ರಿ ನಾನು.
ಆಯ್ತು. What about this matters?
This I will not tomorrow may I reply, or he can also start tomorrow itself.
Tomorrow.
Please.
List finally tomorrow. ಇಲ್ಲ ಮುಗಿಸ್ಬಿಡೋಣ ಇದು ಆಗಿದೆ. Yes, next.
Serial number 13.
No, you are ready in 22.
22, my lord, if your lordship permits me. I have also submitted, my lord, synopsis.
Who is for the other side?
Not he was here, man, Latif.
Shetty.
ಅಲ್ಲ ಸಾಹೇಬ್ರು 13 ಕಾಯ್ತಾ ಇದಾರೆ ಅವ್ರು ಮುಗಿಲಿ ಮೇಡ ದೇರಾಫ್ಟರ್
Yeah,
ಅವ್ರು ಮುಗಿದ್ಮೇಲೆ ಅಂತ
Please inform Mr.
I'll inform
Latif
him.
also.
Please.
Let him come.
ನನಗೆ my lord's direction is that I should be as brief as possible ಅಂತ.
Yes, yes.
That was yesterday's direction.
It was not a direction, sir. It is a request.
Request.
No, but that was the direction.
Courts on the direction.
Who are the appellants?
But there is only one appellant.
Well, there are two appeals. Allah.
One by the state and another by the convicted.
Okay, first one by the state.
By the state.
Yaar idhar state?
Yes, Prasad.
Hmm? Hmm. They are seeking enhancement.
Yes, they have sought for it. They have not challenged the judgment of acquittal of the second accused in the case. They have only sought for enhancement of sentence that is imposed upon the appellant in the second appeal.
Yes.
Please. But I shall just give your lordship brief facts of the case, just about 2-3 minutes. Then I
The
shall take,
designation of accused number one,
yes, accused number one.
what he was working as.
I was a corporator
Hmm.
according to the prosecution by the, during the relevant time.
Yes.
Well, conviction is for an offense under section 7
Hmm.
and 13(1), which is made penal under section 13(2) of the Prevention of Corruption Act.
Yes. Yes. Proceed.
Well, the first informant in the case who has been examined as PW1.
In all, how many witnesses are examined?
In all, there are 8 witnesses.
Exhibits E1 to
PW1 is Uday Kumar. He is the first informant in the case.
who is PW2?
PW2 Sandeep Rawat and PW3 Ramachar
No, what PW2
are
says?
the punch witnesses.
Who is the shadow witness?
But though there is a reference in the judgment passed by the learned trial judge that there is a shadow witness who is none other than, according to the learned judge, it is PW2, Sandeep Rawat. He in fact is not a shadow witness at all, and there are no shadow witnesses in the case. I shall take your lordship a
No,
little.
according to the case of the prosecution, who
According to
is
the case of the prosecution,
the shadow witness?
there is no shadow witness at all.
Even as per case of.
No, as per the prosecution, but as per the learned trial judge, PW2 Sandeep Rawat is a shadow witness.
PW4,
CW3 is a punch witness, my lord, Ramachar. PW4 Renuka Radhya is an official who is examined to speak to the sanction that has been accorded for prosecution of the petitioner.
yes, then
As per exhibit P14.
PW5,
PW5 Timegowda and PW6 Tamaya are 2 officials attached to BBMP.
what they say,
Well, they are treated hostile by the prosecution.
what they are supposed to say,
They are supposed to say, my lord, that it was at the instance of the appellant accused that the construction was threatened to be stopped unless and until he pays some amount by way of bribe. But they would say, my lord, as per the instructions given to them by their higher ups, that is the executive engineer, they went there and stopped the construction, which was an unauthorized one, admittedly an unauthorized structure.
Both hostile,
5 and 6, both.
PW 7,
7 and 8. 7 is Ravi Shankar, 8 is Manjunath. They are the investigators.
who registered the FIR?
It is PW 8 Manjunath.
Yes,
Please. But Uday Kumar was putting up a structure. According to the prosecution, that comes within the area to which this appellant accused was elected as a corporator
yes.
of Bruhat Bangalore Mahanagara Paliki, BBMP. Well, the sanction plan was only to put up the 3 floors, that is ground, first and second.
Yes,
According to the prosecution, my lord, he had undertaken the work of putting up a 4th floor unauthorizedly. While he was putting up the 4th floor, there was no obstruction whatsoever from the authorities attached to the corporation.
yes.
The construction of the 4th floor was almost over by 80%. It was at that point of time, according to the prosecution, the appellant accused would send a message through his relation who is labeled as accused number 2 in the case for payment of certain amount by way of bribe to regularize the unauthorized construction which he had undertaken.
Yes.
ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ ಈ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಅದನ್ನ P6 ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ. Still, I'm sorry. Doesn't matter. Then, my lord, after completion of investigation, a charge sheet came to be laid against the accused for an offence which is made penal under section 7 as well as under section 13 of the PC Act. Well, this in a nutshell is the case of the prosecution as projected not only in the final report that is filed in the case, but also during the trial. But the crux of the matter is the pre-trap mahzar, which in common parlance we call it as an entrustment mahzar. I'm sure your lordship would agree with me. And then the trap mahzar. These are the two important documents on which the prosecution has got to place reliance in support of its case. Exhibit P3 and Exhibit P7.
Yes, you please read Exhibit P6.
P6, man.
Ah.
ಮಾನ್ಯರೇ, ಗೋವಿಂದರಾಜು ನಾನು ನನ್ನ ಸ್ನೇಹಿತ ಕಿರಣ್ ಎಂಬುವರಿಗೆ ಈ ಫೈನಾನ್ಸ್ ಉದಯ ಎಂಬುವನ ಹತ್ತಿರ ನನಗೆ 2 ಲಕ್ಷ ಹಣವನ್ನು ಕೊಡಿಸು ಎಂದು ಹೇಳಿದ. ಅದಕ್ಕೆ
Govindaraj?
Madam?
Who is Govindaraj?
He is the appellant before you, Lord.
Okay.
That is his statement to the accused, my lord, at the time of trial. My lord, if my lord permits me, I shall read it right now, but I shall take your lordship to this little later. I shall demonstrate, my lord. If I am able to demonstrate before your lordship, number one, the pre-trap mahzar and the trap mahzar are false, concocted and fabricated documents.
I'll come to that, but let me understand what is your explanation.
That is a loan amount, that is what I submitted to your lord.
ಅದು ಒಂಚೂರು ಓದ್ಬಿಟ್ಟು.
ಓದ್ತೀನಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಕೊಡಿಸು ಎಂದು ಕೇಳಿದ. ಎಲ್ ಗೋವಿಂದರಾಜು ನಾನು ನನ್ನ ಸ್ನೇಹಿತ ಕಿರಣ್ ಎಂಬುವನಿಗೆ ಈ ಫೈನಾನ್ಷಿಯರ್ ಉದಯ ಎಂಬುವನ ಹತ್ತಿರ ನನಗೆ 2 ಲಕ್ಷ ಹಣವನ್ನು ಕೊಡಿಸು ಎಂದು ಕೇಳಿದ. ಅದಕ್ಕೆ ನಾನು ಅವನ ಹತ್ತಿರ ಕೇಳುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿದೆ. ಸರಿ, ಹಾಗಾದರೆ ನಿನ್ನವರು ಕೊಡು ಎಂದು ಹೇಳಿದ. ನನ್ನ ಹತ್ತಿರ ಇಲ್ಲ, ನನ್ನ ಎಲೆಕ್ಷನ್ ಎಲ್ಲ ಖಾಲಿಯಾಗಿದೆ ಎಂದು ಹೇಳಿದೆ. ಆಗ ನನಗೆ ನೆನಪಿಗೆ ಬಂದಿದ್ದು ಈ ಫೈನಾನ್ಷಿಯರ್ ಉದಯ್ ಎಂಬುವರು. ನಾನು ಮತ್ತು ನನ್ನ ಸ್ನೇಹಿತ
ಉದಯ್ ಇಸ್ ಕಂಪ್ಲೇನೆಂಟ್.
ಉದಯ್ ಇಸ್ ಕಂಪ್ಲೇನೆಂಟ್. ನಾನು ಮತ್ತು ನನ್ನ ಸ್ನೇಹಿತ ಹೋದಾಗ ನೀನು ನನಗೆ ಸಾಕ್ಷಿ ಇದ್ದರೆ ಮಾತ್ರ ನಾನು ಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ. ನಾನು ಒಬ್ಬ ಕಾರ್ಪೊರೇಟರ್ ಆಗಿ ಸಾಕ್ಷಿ ಹಾಕುವುದಕ್ಕೆ ಆಗಲ್ಲ ಎಂದು ಹೇಳಿದೆ. ಆಮೇಲೆ 2 ದಿವಸ ಕಳೆದ ನಂತರ ಅವನು ಮನೆಗೆ ಹಣವನ್ನು ತಂದು ಕೊಟ್ಟ. ನಾನು ಅವನ ಕಿರಣ್ ಕೈಗೆ ಕೊಡು ಎಂದು ಹೇಳಿದೆ. ಉದಯ ಫೈನಾನ್ಸ್ ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ ಎಂದು ಹೇಳಿ ನನ್ನ ಕೈಯಲ್ಲಿ ಕೊಟ್ಟು ಯಾರು ಹೇಳಿ ಉದಯನಿಗೆ ಪ್ರಾಣ ಭಯವಿಟ್ಟು ಅವನನ್ನು ಈ ರೀತಿ ತಪ್ಪು ದಾರಿಗೆ ಎಳೆದಿದ್ದಾರೆ. ಅವನು ಬಹಳ ಜನರ ಹತ್ತಿರ ಫೈನಾನ್ಸ್ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದಾನೆ. ಯಾರೋ ನನಗೆ ಆಗದಿದ್ದವರು ಈ ಕೆಲಸವನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ನಾನು ಸಮಾಜಕ್ಕೆ ಒಳ್ಳೆಯ ಕೆಲಸವನ್ನು ಮಾಡುವುದು, ನನಗೆ ಈ ರೀತಿ ಬಂದಂತ ಹಣ ನನಗೆ ಬೇಕಾಗಿಲ್ಲ. ದಯವಿಟ್ಟು ನನ್ನ ಮೇಲೆ ನಂಬಿಕೆ ಇಟ್ಟು ಸಮಾಜಕ್ಕೆ ಒಳ್ಳೆಯ ಕೆಲಸವನ್ನು ಮಾಡಲು ಬಿಡಿ ಎಂದು ಕೇಳಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. Well, now, by first submission to your lordship, before I take your lordship to the merits of the matter, and in particular to exhibits P3 and P7, the trap mahzar and the pre-trap mahzar, if I am able to demonstrate to your lordship that these 2 documents are concocted, got up by the investigator sitting in the Lokayukta office itself, but I'm sure your lordship would certainly accept my submissions and grant me the relief which I have sought for in this case. But prior to me taking your lordship to the facts of the case, well, I shall invite my lord's kind attention to first the sanction for prosecution in this case. Well, I am a corporator.
What are your defense then?
Well, my defenses are manifolded. Firstly, if my lord is persuaded to accept my submission,
No.
there is no proper
Grounds-
sanction.
Grounds for challenge.
Yes, I am sure.
You are disputing the sanction also.
Yes, my lord, everything I am doing it.
Hmm.
My lord, if I am able to demonstrate your lordship that there is no sanction at all, valid sanction at all, straight away, my lord, I am entitled for a judgment of acquittal at your lordship's hands while sitting at not there.
There is no valid sanction, second one.
No valid sanction. Number two, but he could not have held me guilty of an offence under section 13(1) for the violation of section 13(1), which is made penal under section 13(2). Well, kindly have a look at section 13(1) for a second, Miller, now that your lordship is
But
asking me.
you can elaborate later.
Yes, yes. Number three, well, there was the settled legal position is demand and acceptance is sine qua non.
Yes,
I think I need not trouble your lordship on that issue.
yes.
That is a settled legal position as on this day. Demand and acceptance is sine qua non. As my lord has pointed out a little earlier, but the object of sending a shadow witness, despite he being available, despite his presence being secured, is to get the corroboration to the say of the informant bribe giver with regard to the demand and acceptance.
Yes. So according to you, there were no shadow witness.
No shadow witness. Shadow witness was there. He was not sent. But the learned judge would say, no, PW2 is the shadow witness. He is a punch witness, my lord. I can straight away take your lordship to that.
Yes, then.
That is it. Next, my lord, exhibit P1, the entrustment panchanama, which goes along with, exhibit P3, which goes along with P4, further entrustment panchanama, P3 and P4, and P7, the trap mahazar are concocted and they came to be drawn sitting in the office of Lokayukta in the absence of the punch witnesses and the complainant. And their signatures came to be obtained later. That is the evidence.
Yes.
But if my lord were to accept my submission, ignoring everything, my defense and all those things, that P3, P4 and P7 are false, fabricated and concocted documents.
Yes.
But the case of the prosecution must fall like 9 pins. Now, my lord, I shall first deal with the sanction aspect. May I just request your lordship to kindly turn to ink page 7 in the paper book. That is a sanction order. Just to refresh my lord's memory, day in and day out, your lordship would be coming across section 19. Just for my satisfaction, let me draw my lord's kind attention to section 19. Have a look at section 19, my lord, just to refresh my lord's memory. No court shall take cognizance. My lord gets it?
Yes, yes.
No court shall take cognizance of an offence punishable under section 7, 11, 13 and 15, alleged to have been committed by a public servant except with the previous sanction, save as otherwise provided in the Lokpal or Lokayukta Act. A. In case of a person who is employed or as the case may be was at the time of commission of the alleged offence employed in connection with the affairs of the union and is not removable from his office save by or with the sanction of the central government of that government. Well, probably I'm sure your lordship would agree with me. A will have no application as far as I am concerned. I'm a corporator, elected representative. B. In the case of a person who is employed or as the case may be was at the time of commission of the alleged offence employed in connection with the affairs of the state, he is not removable from the office save by the sanction of the state government or that government. B will have no application. C. In any other person, in the case of any other person of the authority competent to remove him from his office. Well, the sanction should have been or ought to have been given by an authority which is competent to remove me from my office.
Yes.
But I'm posing this question to myself. I'm an elected representative. Who is the one who is competent to remove me from the office I have been holding is the question which I am posing for myself.
Yes.
It can't be chief minister. It can't be minister for urban development. Or it can't be a minister for Bangalore city development. No one can remove me. People have voted for me and I am elected. So whether the question is whether I would come under C or not. Well, I would be failing in my duty if I do not invite my Lord's kind attention to section 26 of the Karnataka Municipal Corporation Act.
26.
Section 26, man.
40.
Yes. Well, this would only give us an indication, not that section 26 of the Karnataka Municipal Corporation Act enables an authority to remove me from the office. No. It only gives us an indication who could have been the one who is competent to accord sanction, if at all he is clothed with the powers of according such sanction for prosecution under section 19 of the Prevention of Corruption Act. It only gives an indication.
Corporation. Yes.
May I request your Lordship to kindly turn to section 26. General disqualification for becoming a councillor. But this needs to be examined. My submission to your Lordship is by your Lordship. My submission to your Lordship is this does not certainly clothe any powers upon the authority concerned who has been defined under section 26 to remove me from the office which I have been holding as a corporator. Still, my Lord, it gives us an indication that he could have been the person. That is all what I am submitting. Well, now kindly go to a person shall be disqualified for being chosen as and for being a councillor if he has been sentenced by a criminal court to imprisonment for an offence punishable with imprisonment for a term exceeding 6 months, provided that the offence is one which involves moral turpitude. 2, such sentence has not been reversed or quashed or the offence not pardoned. If he is convicted of an offence under the provisions of the Untouchability Act 1955 or the Prevention of Food Adulteration Act, then it is a big section. Then now kindly go to my lord, 26(1) capital A 2 proviso. My lord gets it.
Yes, I have to. Please read it.
Please. I'm sorry. Provided further, when the application is made by a councillor to the corporation for leave to absent himself and the corporation fails to inform the applicant of its decision on the application within a period of 1 month from the date of the application, the leave applied for shall be deemed to have been granted by the corporation. ಇಲ್ಲಿ ಒಂದು amendment introduce ಮಾಡಿದ್ದಾರೆ. The regional commissioner may either suo moto or on a report made to him after such inquiry as he deems fit by order decide whether the seat of the person concerned has become vacant or not. As far as may be, such order shall be made within 30 days from the date of receipt of the report or where action is taken suo moto within 30 days from the initiation thereof. Well, the regional commissioner has been given the power. This would indicate that he is the one who is competent to accord a sanction in the event of he having been clothed with any such power.
Who is PW4?
Well, PW4 is an undersecretary to government. I shall take your lordship to that now. PW4, Renaka Radhya, is an undersecretary. It is the regional commissioner under section 26. If at all he has any powers. For a moment, my lord, I am not conceding that he has the powers, but that only gives us an indication that he is a competent authority to order the disqualification. May I now request your lordship to kindly turn to page 7, the sanction order.
1 minute, 1 minute.
Yes, ma'am. The sanction order, my lord, is dated 16/9/2010. Madam, 13/9/2010, there was a sanction order. Prior to this sanction order of 16/9/2010, which has been marked as Exhibit P14 in the case, there was a sanction order on 13/9/2010.
Trap was on 16.
Yes, madam?
Trap was on 16,
Yes. 17th.
17.
17th. 17th, 7. 17th, 7. That is 2 months prior to this. Well, my respectful submission to your lordship is that sanction order for prosecution, which was given on 13/9/2010, came to be destroyed because it was not in accordance with the provisions which mandated such sanction for prosecution. I shall show to your lordship now. Then, my lord, the police people, the police personnel would ask the government, they say the earlier sanction order which you have sent to us on 13/9/2010 is not in accordance with law. Prepare a fresh sanction order.
Exhibit P40. Yes,
Prepare a fresh sanction order and send a fresh order to us. Take back this order of 13/9. The government in its wisdom would say, yes, yes, we are going to rescind that sanction order of 13/9 and we are going to issue a fresh order.
yes.
Well, may I just request your lordship to now kindly turn to ink page 7 of the paper book.
What is that?
But this is a sanction order of 16/9. This also makes a reference to a shadow witness who is not in existence at all.
One minute. No, only exhibit P29. There is no 40 alla.
Which one, Miller?
Sanction order is exhibit
P14.
14.
Howdo? Ink page 7 of my paper book.
14.
Paper book. My lord has the paper book, Miller?
No, I am looking at the original records.
Sir, sir.
Yes.
Kindly permit me to take your lordship to first paragraph, Miller. ತನಿಖಾ ದಾಖಲಾತಿಗಳಲ್ಲಿ ಎಕ್ಸೆಟ್ರಾ ಓದಲಾದ 21/7/2010 11/8/2021 ಹೆಚ್ಚುವರಿ ಪೊಲೀಸ್ ವಿಭಾಗ ಅಭಿಯೋಜನೆಗೆ ಒಳಪಡಿಸಲು ಲಂಚ ನಿರೋಧಕ ಕಾಯ್ದೆ 19(1)B ಕಲಂ ಅಡಿಯಲ್ಲಿ ಸರ್ಕಾರದ ಮಂಜೂರಾತಿಯನ್ನು ಕೋರಿದ್ದರ ಮೇಲೆಗೆ ಓದಲಾದ ದಿನಾಂಕ, ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ದಿಸ್ ಮೆಲೋಡ್, 13/9/2010 ಆದೇಶದಲ್ಲಿ ಗೋವಿಂದರಾಜು ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಸದಸ್ಯರು ಲಂಚ ನಿರೋಧ ಕಾಯ್ದೆ 7 ಸೆಕ್ಷನ್ ಕಲಂ 13(1)D ಸಹವಾಚನ 13(2) ಸಹಾಯದಲ್ಲಿ ಅಭಿವೃದ್ಧಿಗೊಳಿಸಲು ಕರ್ನಾಟಕ ಪೌರಗಳ ನಿಯಮ 1976 ಕಲಂ 487 ದತ್ತವಾದ ಅಧಿಕಾರ ಚಲಾಯಿಸಿ ಸರ್ಕಾರ ಮಂಜೂರಾತಿ ನೀಡಲಾಗಿತ್ತು. 487 ನಲ್ಲಿ ಅದು ಕರ್ನಾಟಕ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್ ಆಕ್ಟ್. ನೋ, ದಟ್ ಡಸ್ ನಾಟ್ ಎನೇಬಲ್. ಮೇಲ್ಕಂಡ ಸದರಿ ಸರ್ಕಾರಿ ಆದೇಶದಲ್ಲಿ ಕೆಲವೊಂದು ನ್ಯೂನತೆಗಳು ಕಂಡು ಬಂದಿದ್ದರಿಂದ ಅವುಗಳನ್ನು ಸರಿಪಡಿಸಿ ಪರಿಷ್ಕೃತ ಮಂಜೂರಾತಿ ಆದೇಶವನ್ನು ಹೊರಡಿಸುವಂತೆ ಹೆಚ್ಚುವರಿ ಪೊಲೀಸ್ ಮಹಾನಿರ್ದೇಶಕರು ಲೋಕಾಯುಕ್ತ ಇವರು ಮೇಲೆ 5ರಲ್ಲಿ ಓದಲಾದ ದಿನಾಂಕ 16/9/2020 ಕೋರಿರುತ್ತಾರೆ. Take back that, rescind that, then issue a fresh sanction order. We do not know what is that sanction order that was given earlier. That was an exercise of powers said to have been clothed. 487 powers ಇರೋದು ಇದಕ್ಕೆ ಇವರಿಗೆ of the Karnataka Municipal Corporation Act. But that was removed, rescinded. No, my lord, may I request your lordship to kindly turn to ink page 9, paragraph 5 for a second. ಇದರಲ್ಲಿ ಇವರು ಬರೀತಾರೆ. At the middle of paragraph 9, my lord,
Yes.
I would request your lordship to kindly turn to ಟ್ರ್ಯಾಪ್ ಯಶಸ್ವಿಯಾಗಿ ಎಲ್ ಗೋವಿಂದರಾಜು ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಸದಸ್ಯರು ಅಕ್ರಮ ಸಂಭಾವನೆಯಾದ 2 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಸದರಿ ಸರ್ಕಾರಿ ಕೆಲಸವನ್ನು ಮಾಡಲು ಕೇಳಿ ಪಡೆಯುತ್ತಿದ್ದಾಗ ಸಿಕ್ಕಿ ಹಾಕಿಕೊಂಡಿರುತ್ತಾರೆ. ಆಪಾದಿತ ಸಾರ್ವಜನಿಕ, ಇವ್ರದ್ದು ಕಾರ್ಪೊರೇಟರ್ ಸರ್ಕಾರಿ ಕೆಲಸ ಏನಿಲ್ಲ ಇದರಲ್ಲಿ. ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಅನಾಥರೈಸ್ಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಥವಾ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಆಫ್ ಅನಾಥರೈಸ್ಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಯಾವ ಸರ್ಕಾರಿ ಕೆಲಸ ಇಲ್ಲ ಇವರಿಗೆ. ರಾಸಾಯನಿಕ ತಜ್ಞರ ಪರೀಕ್ಷೆ ವರದಿಯಿಂದಲೂ ಸಹ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ನೆರಳು ಸಾಕ್ಷಿಯು ಅಕ್ರಮ ಸಂಭಾವನೆಯ ಬೇಡಿಕೆ ಮತ್ತು ಪಡೆಯುವಿಕೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಫಿರ್ಯಾದಿ ಹಾಗೂ ಆಪಾದಿತ ಸಾರ್ವಜನಿಕ ಅಧಿಕಾರಿ ನೌಕರ ನಡುವಿನ ಸಂಭಾಷಣೆಯನ್ನು ಆಲಿಸಿರುತ್ತಾರೆ. It makes a reference to the statement purported to have been made by this shadow witness, who in fact is not in existence at all. But now kindly go to para 6. ಹೆಚ್ಚುವರಿ ಪೊಲೀಸ್ ಮಹಾನಿರೀಕ್ಷಕರು ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಬೆಂಗಳೂರು ಇವರು ತನಿಖಾ ವರದಿಯೊಂದಿಗೆ ಸರ್ಕಾರಕ್ಕೆ ಕಳುಹಿಸಲಾದ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಗೋವಿಂದರಾಜರು ಒಬ್ಬ ಜವಾಬ್ದಾರಿಯುತ ಜನಪ್ರತಿನಿಧಿಯಾಗಿ ಸಾರ್ವಜನಿಕ ನೌಕರನಾಗಿದ್ದು ತಮ್ಮ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಿರುವುದು ಹಾಗೂ ತಮ್ಮ ಅಧಿಕಾರ ಬಲದಿಂದ ಫಿರ್ಯಾದಿದಾರರಿಗೆ ತೊಂದರೆ ಕೊಡುವ ದೃಷ್ಟಿಯಿಂದ ಅವರಿಗೆ ಅಧಿಕಾರವಿಲ್ಲದಿದ್ದರೂ ಸಹ, but your lordship may take it for granted at this point of time, though not considering for a moment that it is true. But I am a blackmailer. I am an extortionist. I do not come within the ambit or purview of section 7 and 13 of the Prevention of Corruption Act. I am not clothed with any such powers of stoppage of the illegal or unauthorized construction, nor I am clothed with any such powers of regularization of the unauthorized structure.
There are all powerful, sir.
I'm sorry, madam.
Are all powerful. Wrote with everybody, everything.
Legally. I'm an extortionist. I'm a blackmailer. I threatened him, saying that I would stop it. No, I'm nobody to stop it. That is what the evidence here. I'm nobody to regularize the unauthorized structure. It is the commissioner of the corporation who has the power to stop it and to regularize the unauthorized structure to the extent of permissible deviations.
Yes.
So look at that. Now let kindly go to last paragraph, para 8. ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ಸರ್ಕಾರವು ಆಪಾದಿತನನ್ನು ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯ ಸದಸ್ಯರನ್ನು ತೆಗೆದುಹಾಕಲು ಅಧಿಕಾರವುಳ್ಳದ್ದಾಗಿರುತ್ತದೆ. ತೋರಿಸ್ತೇವೆ ಎಲ್ಲಿದೆ.
Yes.
My lord, what they would say here, Now kindly go to next page. But the order which came to be passed.
Yes.
Then para 10, we will rescind the earlier notification that has been issued. But the witness who came to be examined by the prosecution to speak to this sanction order as Exhibit P14 is Renuka Radhya, who has been examined as PW4.
Yes.
Well, may I just request your lordship to kindly turn to the evidence of PW4, Renuka Radhya, which my lord gets at page 90. But I would like to request your lordship to kindly mark this. What the sanction order would say is that the government is competent to accord sanction for prosecution. Your lordship would get this not only in page 9, but also at page 10. It is the government that is competent to accord sanction is what is said in sanction order Exhibit P14. Now kindly go to page 90, the evidence of Renuka Radhya, the undersecretary who came to be examined. But paragraph 2, after receiving the file and report, the matter was sent to the Chief Minister of Government. And after receiving the approval, the order was issued on 13/9.
Yes.
Well, it is not a sanction order. The matter was placed before the Chief Minister and the Chief Minister approves. Then when the sanction order was issued on 13/9, that came to be rescinded and another order came to be issued on 16/9.
Yes.
So what we could gather from the evidence of PW4 Renuka Radhya, the Undersecretary to Government, as well as from Exhibit P14, is that it is a government that is competent to issue the sanction order as mandated under Section 19 of the Prevention of Corruption Act, and certainly not under the provisions of the Karnataka Municipal Corporation Act.
And you submitted no cross-examination to this witness.
But if it is a legal issue, if error is apparently evident, I need not cross-examine him at all. I am placing reliance on the examination in chief itself.
You could have asked how you are competent.
But I can demonstrate to your lordship. He will say that the government is competent. That is what he says. But I am developing an argument on the basis of what he has said in his examination in chief.
Yes.
Least my lord, in the cross-examination, a dent is created by allowing him or giving him a lever to say something or the other. No. Well, now the question is two things. One is, according to PW4 Renuka Radhya, it is the Chief Minister who has approved, and thereafter they would prepare the sanction order as per Exhibit P14. Number one. Number two, the government is competent to accord sanction for prosecution. These are the two things which your lordship would get from Exhibit P14 as well as from the testimony of Renuka Radhya, who has been examined as PW4 in the case. We will confine only up to that. Two things, let me repeat at the risk of repetition. It is the government that is competent, number one. Number two, the Chief Minister has approved, and therefore we have accorded sanction on one side. Number two, for the purpose of according sanction, we had the advantage of the statement of a shadow witness said to have been recorded by the investigator during the course of the investigation of the crime. Then, my lord, the earlier sanction order that was prepared and sent on 13/9 was not very much conducive. Therefore, that came to be rescinded and another fresh sanction order came to be issued on 16/9. These are the four things one could certainly get from the evidence as well as the sanction order.
Yes.
Well, now the government, according to them, well, it is the government that is competent to remove an elected representative who is a corporator. Well, this issue had come up before this honorable court in more than one case. Well, at what this honorable court would say, the pith and substance of the judgment of this honorable court is government means the council of ministers. It leaves no doubt. Chief minister is not the council of ministers. I took your lordship to the evidence of PW4, Redikaradhya, who would say it is the chief minister who has approved. Probably they would have put up a note and he has said approved. Probably that would also indicate, Milan, there has been no proper.
Which is the decision?
Yes. And any number of judgments of this court.
And latest one,
Good,
only
good.
one.
Good. This court first. Justice Nagaprasad. Well, may I request your lordship to kindly turn to page 10 of this judgment, or the order. And the issue came to be framed. Whether sanction accorded by the third respondent, principal secretary in the Department of Animal Husbandry and Fisheries is in consonance with section 19 of the Act. Well, now kindly go to, probably I need not trouble your lordship by taking your lordship to the entire order. Kindly turn to page 12 of this judgment or order. Page 12, Milo.
Yes.
The coordinate bench was again following the cases of Nanjappa and B. Shivshankar
Page
Supra.
number? Page number?
I'm sorry, Milo.
Page number?
Page 32. Last but one page.
Yes.
The coordinate bench was again following the cases of Nanjappa and B. Shivshankar Supra. For the reasons rendered by this court in B. Shivshankar Supra and in the case of Lakshman Rao Peshwe, this petition deserves to succeed on this score alone, as the apex court holds that if sanction is accorded by an incompetent authority, the further proceedings before the concerned court would become a nullity in law. If it is held that it would become a nullity in law, no other issue that is brought before this court need to be considered, and it has to be declared a nullity in law. It is an admitted fact in the case at hand that sanction is accorded to prosecute the petitioner by the third respondent, who is the principal secretary in the Department of Animal Husbandry and Fisheries. The petitioner being a Group A officer, all major penalties will have to be imposed on him only by the government. What penalties the third respondent can impose are minor penalties and not the one that can result in his removal from service. The penalty of removal from service, kindly mark this, my lord, the penalty of removal from service against the petitioner can be imposed only by the government, that is the cabinet.
Sorry to interfere. Is Lakshman Rao case?
Allah, it's Chandrasekhar, Dr. Chandrasekhar.
Lakshman Rao case, adu Supreme Court has set aside. Chandrasekhar.
Oh, Supreme Court did not set it aside. I had argued that matter. I will tell you what I shall cite that judgment also. It was remanded back to this court and this court would give a finding similar to that.
Yes.
What was passed earlier. In fact, I had argued and you were also there with me.
Yes.
You were also there with me.
That's why I'm.
Yes.
This
Sir, in
judgment-
this case,
So,
he was
Supreme
a-
Court ಕೊಡ್ತೀನಿ.
he was a group
I'm sorry,
A
Malak?
officer. Here in this case, the accused was a Group A officer.
ನಮ್ಮವನು ಯಾವ್ದು ಕಾರ್ಪೊರೇಟರ್.
Yes.
But here why I am referring to this,
Yes, it is the cabinet who is.
cabinet that has,
Yes.
ಅವ್ರು ಹೇಳ್ತಾರಲ್ಲ ಸರ್ಕಾರ ಅಂತ, ಸರ್ಕಾರಕ್ಕೆ ಅಧಿಕಾರ ಇದೆ ಅಂತಾರೆ. It is the government that has the power ಅಂತ. Government ಅಂದ್ರೆ ಯಾರು, chief minister can't be the government. It is the cabinet.
Yes.
It is only for that limited purpose I am drawing my lord's kind attention.
Then,
But my learned friend said about Lakshman Rao Peshwe's case. What the Supreme Court has said, Well, earlier, a coordinate bench of this honorable court speaking through Justice Patil. Good. ನಾವು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ವಿ. ಲಕ್ಷ್ಮಣರಾವ್ ಪೇಶ್ವೆನ ನೀವು ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನ ಹೇಳ್ತಾ ಇರೋದು. ಮತ್ತೆ ನೀವೇ ಹೇಳಿದ್ರಿ ಲಕ್ಷ್ಮಣರಾವ್
ಅವ್ರು ಹೇಳಿದ್ರು ನೀವು ಕೊಡೋದು ಬೇಡ. ಆಯ್ತಲ್ಲ ಒಂದು ಆಲ್ರೆಡಿ ಕೊಟ್ರಲ್ಲ. ಮತ್ತೆ ಡೋಂಟ್ ಬರ್ಡನ್ ದಿ ಕೋರ್ಟ್. ನೋಡೋಣ, ಐ ವಿಲ್ ಹಿಯರ್ ಹಿಮ್.
ಅಲ್ಲ ಅವರು ಲಕ್ಷ್ಮಣರಾವ್ ಪೇಶ್ವೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ,
ಹೇಳ್ತಾರೆ.
ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನನ್ನ ಹತ್ರ ಇದೆ.
ಈಗ ಸ್ಯಾಂಕ್ಷನ್ ಅಲ್ಲಿ ಮುಗೀತಾ ನಿಮ್ದು?
ಅಲ್ಲ ಇನ್ನೂ ಇದೆ, ಹೇಳ್ತೀನಿ ಬೇಕಾದ್ರೆ ಸ್ಟಾಪ್ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕಾದ್ರೆ ಅಷ್ಟೇ ಸ್ಟಾಪ್ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ ಸ್ಯಾಂಕ್ಷನ್ ಅಲ್ಲ, ಐ ವಿಲ್ ಹಿಯರ್ ಹಿಮ್.
Doesn't matter. So ultimately,
If I were to accept your contention.
Please, man, I shall stop it at that.
Yes.
Now, my lord, next question. Alla, idon ತೋರಿಸ್ಬಿಡ್ತೇನೆ fabrication. Exhibit P7 trap measure was done in Lokayukta office. I shall just show that. Whole thing should fall like 9 pin. Not at this spot.
Amount was paid in his house.
Trap Panchanama was done sitting in the Lokayukta in the absence of Panchas to the trap measure and the informant to the police. ತೋರಿಸ್ತೀನಿ ನಾನು ಅದನ್ನು.
Yes, ಎಲ್ಲಿದೆ?
Probably this alone is sufficient. May I just request your lordship? And the IO says, I drew it in his house. But the Panchanama itself would say it was drawn in Lokayukta office in the absence of Panchas and the first informant in the case.
Exhibit?
Yes, my lord.
Exhibit.
But the first shall I, even the entrustment mahazar, fabricated mahazar, ಅದನ್ನು ತೋರಿಸ್ತೀನಿ, but trap mahazar ತೋರಿಸ್ಬಿಡ್ತೀನಿ first ನಾನು. Well, may I request your lordship to kindly turn to page the evidence of first the witnesses. What happened?
No, exhibit P5 ಬಂದ್ರಿ. Trap measure.
ಅಲ್ಲ, trap measure exhibit P7. P7. That is at page 25.
Yes.
Kindly have a look at page 25 now for a second. ದಿನಾಂಕ 17/7, that is the date of trap. 17/7/2010 ಬೆಂಗಳೂರು ನಗರ ಡಾಕ್ಟರ್ BR ಅಂಬೇಡ್ಕರ್ ರಸ್ತೆಯಲ್ಲಿರುವ ಬಹುಮಹಡಿ ಕಟ್ಟಡ 4ನೇ ಮಹಡಿಯಲ್ಲಿರುವ ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕ ಶ್ರೀ HS ಮಂಜುನಾಥರ ಕೊಠಡಿಯಲ್ಲಿ ಈ ಕೆಳಕಂಡ ಪಂಚರ ಸಮಕ್ಷಮ ನಡೆಸಿದ ಟ್ರ್ಯಾಪ್ ಪಂಚನಾಮ.
ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಅದು.
ಐ ಆಮ್ ಸಾರಿ ಮ್ಯಾಮ್.
ಪ್ರೀ ಟ್ರ್ಯಾಪ್ ಪಂಚನಾಮದ್ದು ಪ್ರಿಯಂಬಲ್ ಬಂದಿದೆ.
ಇಲ್ಲ ಅಲ್ಲಿ ತೋರಿಸ್ತೀನಿ ನನಗೆ ನೆಕ್ಸ್ಟ್. ಇದು ಹಾಗಾದ್ರೆ ಅಲ್ಲಿ ಬರ್ದಿಲ್ಲ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ. ಹೌದು ಬರ್ದಿಲ್ಲ, ಯಾತಕ್ಕೆ ಬರ್ದಿಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಿ ಗಲಾಟೆ ಆಗ್ಬಹುದು ಅಂತ ಬರೀಲಿಲ್ಲ ಅಂತ. That explanation I don't know how far your lordship would accept it. Now my lord, kindly go to the last page, page 36. Probably this would ward off the doubt which my lord has entertained. ಅದು pre-trap ಪಂಚನಾಮನ incorporate ಮಾಡಿರಬಹುದು, cut and paste ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಂತ. That is the doubt which my lord would have entertained.
Yes.
No, that is warded off. Page 36. Last paragraph. ಮೇಲ್ಕಂಡ ಎಲ್ಲ ನಡವಳಿಕೆಗಳನ್ನು ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಯಲ್ಲಿ ತನಿಖಾಧಿಕಾರಿಯವರ ಕೊಠಡಿಯಲ್ಲಿ ಕಂಪ್ಯೂಟರ್ ಬೆಳಗ್ಗೆ 10:30 4 ಗಂಟೆ ತನಿಖಾಧಿಕಾರಿಯವರ ಸಿಬ್ಬಂದಿ ರಮೇಶ್ ಉತ್ತಲೇಖನ ಟೈಪ್ ಮಾಡಿಸಿರುತ್ತಾರೆ. It leaves no doubt, my lord?
Yes.
But for this Panchanama, which is not spoken to, exhibit P7, by the two Panchas. This is not spoken to by the two Panchas, nor their attention was drawn to this Panchanama. The two Panchas being PW2 Sandeep Rawat and PW3 Ramachar. It is not even shown to them. It is so for the reason that they were not there at all. I shall take your lordship from their evidence that they were not there at all. Kindly mark this, that this Panchanama, drawing of Panchanama commenced at 10:30, page 36, madam, and it came to a conclusion at 4 o'clock. If I am able to show to your lordship that these two persons were not there at all, as spoken to by them, and as is incorporated in another Panchanama, which came to be drawn in the BBMP engineer's office, where they were present till about 12:30.
No, when the trap was conducted?
I'm sorry, madam.
When the trap was conducted, at what time?
Morning, madam.
Before
8:45.
10:30? 8:45.
Yes.
Yes.
Well, may I just request your lordship to kindly turn to this inspector, who is also an IO and who has been examined as PW7, Ravi Shankar, which your lordship would get at page 99. Kindly go to page 99. ಇದು ಹೇಳ್ಬಿಟ್ಟು ನಿಲ್ಲಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಅವಶ್ಯಕತೆ ಇದ್ರೆ ಬಾಕಿದಿಂದ ಎಲ್ಲ ಹೇಳ್ತೀನಿ ನಾನು. Kindly go to he is Inspector of Lokayukta. He is a investigator. Now may I request your lordship to kindly turn to page 103.
No,
Page.
in page number.
Ink page, my compilation, my paper book commences from page 99. His evidence.
I'm looking at the original records.
ಅದು
In page idre.
ಇಂಕ್ ಪೇಜ್ ಹೇಳ್ತೀನಿ ಇದನ್ನು 5 ಅಂತ ಆಗ್ಬೋದು. ಟೈಪ್ಡ್ ಪೇಜ್ 5.
Yes.
My lord, kindly skip 2 or 3 sentences from the top. The part of the top mahazar is typed in the residence of the accused in a laptop.
That is chief examination,
Cross-examination.
cross-exam.
Internal page 5 of the deposition.
Yes.
From the top, my lord, 5th sentence from the top. The part of the trap mahazar is typed in the residence of the accused in a laptop, and that connected to the happenings in the house of the accused. What happened in the house of the accused is the one which came to be typed sitting in the house of the accused. Well, 2 things would emerge. Kindly permit me to make this submission. The trap panchanama which came to be prepared or drawn or typed at the residence of the accused, no sooner the accused came to be trapped,
Yes.
has been suppressed, destroyed, concealed. For what? Because it was not palatable to the case of the prosecution, would be my respectful submission. Now kindly read the next sentence. It will not stop there. It is not a chance admission which he would give in the cross-examination. He would even go to the extent of saying, IO dictated the trap panchanama at the residence.
Yes.
Kindly read the next sentence below. I have observed the recovery of amount, hand wash, seizure of towels, clothes, etc. Typing was done by Dayananda and sometimes by Yogesh. Both of them were present. I cannot say which sequence were typed in the laptop as IO was supervising it and was dictating. Typing was first started by Yogesh. I was outside the house of the accused between 9 and 9:45. Between 9 and 9:45, IO was dictating and typist was typing. But the mystery is, it is not that. The exhibit P7 would indicate that P7, the trap mahazar, came to be written sitting in the office of the Lokayukta,
Yes.
while suppressing the earlier trap mahazar which they had prepared sitting at the residence of the accused. Of all the happenings that took place. Well, at this part of the evidence is given not by any other person but by the IO. Well, now I did make a submission that PW1 and PW2 were not there at all, who have subscribed their signature to exhibit P7.
Yes.
Now I shall show to your lordship that they were not there. Commencing from 10:30 to 12:45, they were not there at all. May I just request your lordship to kindly turn to the evidence of PW3 first. No, PW2 itself I shall take first. PW2. May I request your lordship to kindly turn to page 79 of my paper book. He was on a different assignment in the engineer's office at Lokayukta, going there at 9:45. My lord gets it, madam. That is the evidence of PW2,
Yes,
internal page, 5 minutes. 5, if my lord is looking into the original,
yes.
internal page 5. Kindly permit me to read to your lordship these paragraphs. As the place was not conducive to continue the proceedings, they decided to continue the proceedings in Lokayukta office. ಇಲ್ಲಿ continuation of ಅಲ್ಲ, ಶುರುನೇ ಲೋಕಾಯುಕ್ತ ಆಫೀಸ್ ನಲ್ಲಿ from the top.
Yes,
There the teams were divided into two. The team headed by Ravi Shankar. Well, this Ravi Shankar, I take your lordship to the evidence. He is PW7, the inspector. Headed by Ravi Shankar, consisted of me, the complainant, and Lokayukta officials. The team headed by DYSP went to Lokayukta office. These 3 persons and their staff. Our team went towards the apartment as per the instructions of DYSP. There is an examination in chief.
apartment belonging to,
The first informant was constructing the unauthorized building. Our team went towards the apartment as per the instructions of DYSP. From thereafter, we went to BBMP ward office. When we went to BBMP ward office, there were 2 persons, including one Venkatesh. The persons present there were inquired about the construction of equipments brought from the construction site, and they showed that they had brought on the instructions of AEE. At about 12:30 p.m., we returned to Lokayukta office. Both are not there. PW1 is not there. PW2 is not there. How did they subscribe their signatures to a trap Panchanama said to have been drawn in the Lokayukta office between 10:30 and onwards, 10:30 and onwards? Up to 12:30, they were not there at all. Well, that is why neither PW1 or PW2 or PW3 would speak to Exhibit P7. No, they don't speak. It was not even shown to them. Their signatures are not even identified. But another interesting fact is how they have fabricated. May I just request your lordship to kindly turn to the evidence of Ramachari. I'm sorry, this page 82. Kindly go to page 82 of the same witness.
PW,
Same, but he is PW2,
yes,
Sandeep. What transpired prior to he going to Lokayukta? Well, just 2 sentences.
cross-examination dated,
Cross-examination, internal page 8 of the deposition.
no, dated,
But this is dated 28/7/2012.
yes,
28. Kindly go to page 8, internal page 8. There was no writing or typing in the house of the accused. Right? He can't be more loyal than the king. The king is the IO. He says it was dictated. What all that transpired, it was written. Probably they wanted to overcome. Well, from the bottom, about 10 sentences above, this would be very, very important. Look at this, Miller. From the bottom, about 10 sentences above. Again, the serial numbers of the currency notes were not printed in the Lokayukta office. My lord gets it, Miller? From the bottom, about 7 or 8 sentences above, Miller, your lordship would get that timings just above that.
yes,
In the house itself, The currency notes were packed and sealed. Well, how did they incorporate this 5 pages description of notes in Exhibit P7, commencing from page 27? How did they incorporate? If it was packed, sealed, not opened, could not have opened after packing it and sealing it. Where did they get this? Well, Exhibit P7. May I just request your lordship to kindly turn to in Exhibit P7, the Panchanama, commencing from page 27. It runs to 4 or 5 pages. It is not one note or 2 notes or 20 notes, 400 notes.
Yes.
Well, it was packed, sealed. The house, in the house itself, the currency notes were packed and sealed. The Mahazar was started when I went to the Lokayukta office. Correct? Obviously, it is incorrect. 10:30, it has started, as is evident from the endorsement made in the last paragraph of Exhibit P7. Now, commencing from page, have a look at this, my lord. Page 27. Have a look at page 27 for a second of Exhibit P7. Where did they get this number?
Yes.
If it was sealed and packed, if no Panchanama was drawn in the house of the accused, is it their case that it was again opened, the packet was opened, seal was removed, it was incorporated? I can understand, my lord, they are making a memory.
Yes.
1 note or 2 notes or 3 notes. 400 notes. They would incorporate it.
Yes.
But now I shall take your lordship to the evidence of PW1. He would also endorse what PW2 has said. We were not there. May I request your lordship to kindly turn to PW1. And fabrication, there must be some limit. My lord gets PW1, my lord?
Yes.
Yes. Kindly go to he endorses what PW2 has said. Page 23, my lord. Page 73. Internal page 24, my lord, of PW1.
Yes.
From the bottom, about 10 or 12 sentences above. There was no writing in the house of accused number 1. And the trap proceedings in the Lokayukta office. After I went there from BBMP office, it was 12:45 p.m. Kindly see this minute. Last paragraph. The serial number of the currency note that was typed on the previous day were verified and typed. This is the recovery Panchanama. The currency notes were also verified in the Lokayukta office during trap Mahazar, which they could not have because it was, according to PW2, it was sealed by putting an initial K, and that seal was given to this witness, PW2. That is his evidence. Or is it their case that they have meddled with it? Well, if my lord is persuaded to accept my submission from the evidence of Mr. Ravi Shankar, the inspector of police of Lokaयुಕ್ta, who is examined as PW 7, that at the sitting in the residence of the accused where the trap proceedings took place, a Panchanama was drawn
Yes.
of the events which that had happened in the house of the accused. Number one, it is the IO who dictated the contents of that trap Panchanama. Number two, that trap Panchanama is not there at all.
Yes.
What your lordship could see as per exhibit P7 is the trap Panchanama which came to be drawn sitting in the office of the Lokayukta. Number three, well, the signatories to this trap Panchanama which came to be drawn in the office of the Lokayukta, as per exhibit P7, is said to have been attested not only by PW1 but also by PW2. This was done at a point of time when PW1 and PW2 were not there in the Lokayukta office at all, because they entered into the Lokayukta office after 12:30. Whereas the endorsement made in exhibit P7 would indicate that this trap Panchanama which came to be drawn in the Lokayukta office commenced at 10:30. So my respectful submission to your lordship is, if my lord is persuaded to accept my submission, that this trap Panchanama exhibit P7 is a false, fabricated and a got up document sitting in the office of the Lokayukta, would be my respectful submission. That is number one. Number two, the earlier trap Panchanama which came to be drawn sitting in the house of the accused, as spoken to by PW 7 Ravi Shankar, the inspector of police, has been either destroyed or concealed for the reason that it would go against the case of the prosecution.
Yes.
Added to this, PW1, PW2, PW3 do not speak to exhibit P7 at all, despite the fact that it was drawn sitting in the office of the Lokayukta.
It was not shown to the witnesses.
Not even shown. Well, at this point of time, it would be useful for me to draw my lord's kind attention, since my lord has repeatedly posed that question to me, whether a shadow witness was there or not. Despite the fact that the latter trial judge, in the course of the judgment, would refer to shadow witness. I do not know who is that shadow witness. May I request your lordship to kindly for a second, only one sentence in 3 paragraphs of the judgment of the latter trial judge. May I request your lordship to kindly turn to internal page 35 of the judgment, if my lord has been having the original. Paragraph 41.
Yes.
At the bottom, CW2 shadow witness here Sandeep Rawat has been examined as PW2. No? Now, my lord, may I request your lordship to kindly turn to internal page 131 for a second. Paragraph 157. Let us get it. The Larent Special Public Prosecutor submitted that there is no occasion to disbelieve the evidence of the complainant and shadow witness. Really, that shadow witness.
Yes.
No, my lord. The operative portion, the Larent judge says, I am placing reliance on the testimony of shadow witness. At page 165, paragraph 173. Then I shall take your lordship the endorsement made by the IO himself in the Panchanama that there is no shadow witness in this case. Would your lordship kindly turn to paragraph 173? Thus, the evidence of the complainant PW1 supported the evidence of PW2, the shadow witness. Well, probably, I'm sure your lordship would certainly agree with me, though not the law and trial judge. Shadow witness is different from punch witness. Well, a shadow witness means the very nomenclature of the word shadow itself would indicate one who follows the informant. As I submitted to your lordship a little earlier, sine qua non, demand and acceptance to get corroboration to the say of the informant or the bribe giver, that when the trap proceed prior to the trap proceedings, when the amount came to be put into the hands of the accused did make a demand for the payment of the bribe amount. That has got to get corroborated by some evidence or the other. The some evidence or the other is nothing but the evidence of the shadow witness. May I now request you, Lordship, to kindly turn to Exhibit P3. Well, he himself would endorse, the AO would endorse. It continues in page Exhibit P4.
Why there were additional pre-trap Mahazar?
Well, that is another fabrication. If my lord wants me to make that submission also, I shall make that submission. 16ನೇ ತಾರೀಕು ದುಡ್ಡು ಕೊಟ್ಟುಬಿಟ್ರೆ ಇವರು ಐವೋಗೆ
So previous day.
ಪ್ರೀವಿಯಸ್ ಡೇನೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. But what he says is no, complainant says no, I did not give any amount to the IO on 16th. This Panchanama is on 16th. Lord, may I request your lordship to kindly turn to ink page 20 of this extended entrustment Mahazar dated 17/7. Internal page 2. That has been marked as Exhibit P4. Kindly go to page 2. ತನಿಖಾಧಿಕಾರಿಗಳು ನೆರಳು ಸಾಕ್ಷಿದಾರರಿಗೆ ನೀಡಿದ ಸೂಚನೆಗಳೇ ವಿವರಗಳು. My lord gets it, Parad?
Yes.
Yes. ಫಿರ್ಯಾದುದಾರರ ಜೊತೆಯಲ್ಲಿ ಯಾರಾದರೂ ಹೋದರೆ ಆರೋಪಿತರಿಗೆ ಅನುಮಾನ ಬರುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಫಿರ್ಯಾದುದಾರರ ಕೋರಿಕೆಯಂತೆ ಅವರ ಜೊತೆಯಲ್ಲಿ ನೆರಳು ಸಾಕ್ಷಿದಾರರನ್ನು ಕಳುಹಿಸಿರುವುದಿಲ್ಲ. What a tragedy. He is there. I shall show to you, lordship, who is that fellow. That person, my lord, is one Venkatesh. He goes. He is not examined. My lord, accepting this, recovery, my lord, the settled legal position is merely because the amount is recovered. It does not face any liability upon the accused for an offence under section 7 or under section 13(2). That is a settled legal position. Who is the shadow witness then, according to the learned judge? PW2? PW2, no. He says, no. I went along with the IO after the first informant gave a signal. How could he be the shadow witness? And he was not even present when the Exhibit P7 was drawn.
Yes. Yes.
ಇನ್ನು
Let me
ಬೇಕಾದಷ್ಟಿದೆ.
hear it.
ಅಷ್ಟೇ deeply obliged.
Sanction point, my lord, they raised first time before this Honorable High Court. They are not at all cross-examined before the trial court. First time before the appellate court, it is not permissible.
Question of law.
Question, even though, my lord,
The competent.
Supreme Court decision is, the sanction also, order also is a valid sanction order. I will submit that aspect also.
No, whether
And
the
the first time, my lord,
whether the undersecretary to the government was
yes,
competent
competent of that.
remove-
Satyan case is very clear, my lord, it's a department, concerned department. Chief Minister is a concerned department head and a minister of that urban development, the local board. On that point of time, my lord, Chief Minister is a head of the, he accorded his permission, his accorded the sanction. And it is permissible.
No, no. The first sanction that was before trap.
No,
For that, the CM has accorded.
no,
permission.
39, 30, it's not 39,
39.
27 is a trap.
ಆಯ್ತಲ್ಲ ಇವಾಗ ಅವರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ರಲ್ವಾ?
Argument ಅವ್ರು ಹೇಳಿರೋದು trap conducted in 17/7
ಹಾ.
and after that the final report is submitted before the competent authority.
Trap was on
17/7/2010. 2010, after lapse of 2 months, investigation is completed.
Yes. ಆಯ್ತು.
13/9, after lapse of 2 months, investigation is completed
Yes.
and submitted a report, final report.
No, 13/9, that was withdrawn. I think.
Yes, fresh sanction is not fresh sanction. It's rectify the typographical error and all, and they are not at all cross-examined that aspect. They are given an opportunity before the trial court, and they are not at all raised an objection before the trial court. They are not at all raised any voice with regard to the sanction order, and in the appeal memo also. First time in argument, they are saying that, my lord, this is a sanction order. These are all the defect is there. One reported judgment, my lord, is the Supreme Court decision. I will give that judgment also. First time they can't raise this objection.
ಯಾವ್ದು citation?
I will xerox copy. 2020 part 17 Supreme Court case 664.
2020.
Part 17 SCC 664 para 11.
Yes. Good.
Further, the issues of relating to the validity of the sanction for the prosecution could have been considered only during the trial, since essentially the conclusion reached by the High Court is with regard to the defective sanction, since according to the High Court, the procedure providing the opportunity for the explanation was not followed, which will result the sanction being defective. These are section para 11. It's clear that, my lord, that they are at the initial stage. I will the number of decision I will cite that in this
ಇದ್ರಲ್ಲಿ
aspect.
ಆ ರೀತಿ ಬಂದಿಲ್ಲ.
Pardon?
Now just now you read, it does not mean so.
I will first time they raised in the argument, it is not in the appeal memo also. That's why, my lord, I will produce produce the Supreme Court decision on this aspect. And it's
Yes.
Under Secretary is concerned, my lord, he is a competent authority, the permission of the Chief Minister, and Satyan case is very clear, my lord. It's ಅಲ್ಲ ನಾನು ಫಸ್ಟಿಗೆ
ಅದನ್ನು ಹೇಳಿದ್ರೆ
ಅಲ್ಲ ನಾನು ಎರಡು ಸೈಟೇಷನ್ ಕೊಡ್ತೀನಿ. 130 ನಾನು ಕೊಡ್ತೀನಿ. 130 ನಾನು ಕೊಡ್ತೀನಿ. I will cite decision. Because it's a surprise, my lord, is a first time in the argument, not in the appeal memo also. That's why, my lord, the trial court gave a finding on that aspect also. And there is no cross examination for the sanction order.
That was raised by the learned senior advocate.
Yes, my lord, this is the first time.
Yes.
And the admitted fact, my lord, is need not be proved. It's not an IPC offense. It's in section 20, presumption is there. Once he admitted that, my lord, categorical admission in a cross examination as well as his defense evidence, he admitted that, my lord, he received the money. DW1, as per the DW1, his witness says that, my lord, it's a loan transaction.
First, the burden is on the prosecution.
Yes, my lord. Once it's admitted fact, it need not be.
What admitted? He admitted that it was a loan amount that was paid by the complainant.
Yes,
That cannot
in the
be
313 statement also, my lord, I want to go through the 313 statement.
Independently, the prosecution is
Once
required to prove.
Yes,
the
my lord.
demand. First demand, thereafter accept.
Yes, I will come to that aspect. I will come to that aspect. PW1 evidence as well as the PW2, 3 evidence also, my lord.
ನೀವು ಸುಮ್ಮನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ. ಶೋ ಮಿ ದಿ evidence of the witnesses.
Yes,
It would be
DW1,
easy
my lord,
for-
DW1 evidence.
First show your witnesses, prosecution. What is their evidence regarding demand and acceptance?
Yes, my lord, complaint PW1. Page number 2, earlier demand. Page number 3. Second para. Middle of that. He told me if the amount is not paid to him, he would ensure the KEB connection will not be available to the building. Even he would see that the building is demolished. I was asked to arrange 2 lakhs before Saturday. On 16/7/2010, I had arranged 2 lakhs. Also, when I went to the Lokayukta office, I had mobilized. It also through help from my friends. It's 16/7/2010, and he earned 2 lakhs rupees, and before filing the complaint also. And acceptance, page number 6 in the evidence.
Page number?
6 in evidence.
Hmm.
Last para.
Yes.
Why the shadow witness have followed, why is not followed the complainant?
So admittedly, there was no shadow witness.
Shadow witness is admittedly, my lord, he was not followed at the time of the
So
giving.
he cannot be branded as shadow witness. That is
Yes,
what-
yes.
Yes. So only
He
the
named
complainant-
as a shadow witness.
Only the complainant had gone to the house of the accused,
Yes,
gave the amount.
yes,
Yes. So it is only the evidence of PW1, the complainant is material.
yes, my lord.
Yes.
I was asked to take a witness along with me. I told that accused number 1 would feel doubt and I would go alone. And next 3 para, after 3 para. My friend Venkatesh had brought the scooter and I went in his scooter from that place to the house of the accused number 1 and I pressed the calling bell. His attendant opened the door. I asked about accused number 1 and he sent me inside saying that accused was in home. Accused came out. I told him that I had brought the amount of rupees 2 lakhs, which was demanded by him. He received the amount and I pleaded him saying that would be the last payment and I was not in a position to pay further amount. But accused number 1 said to pay rupees 1 lakh within another 15 days. He went inside the room and he kept that money in his cupboard. At his instance only, he said that money is recovered.
Yes.
And PW2.
PW2 is not a witness either to the
As
demand.
a recovery is concerned. Recovery.
Recovery admitted.
Recovery is it's not in a public place. It is in his house.
Yes.
And he is not disputing that, my lord, is not that amount is not recovered from his house.
That is not disputed.
It is not disputed. Once he admitted that word, my lord, it's section 20 is applicable. Section 20 is very clear. Presumption. Prosecution has to prove that, my lord, demand and acceptance is
Yes.
once
is
acceptance
We should first
not demand and acceptance is approved. And the complaint categorically said that, my lord, he's received the money and he demanded the money. And for that, my lord, last occasion I said that Sharma judgment, it's they are not at all created any doubt with regard to the PW1 complaint evidence. Question of corroborating is concerned, my lord.
To apply section 20 and raise the presumption, prosecution is required to prove the demand, acceptance
Yes,
of the undue advantage,
yes,
acceptance of the undue advantage.
yes, my lord.
That is the burden on the prosecution.
Yes, my lord. That question does not arise in this case because of this reason. If he said that, my lord, I have not received the money, I have not received the money. I have not kept that money in my house.
Sir, burden is on you to prove that the payment of the amount, acceptance of the amount was as bribe amount, as illegal gratification.
Yes,
Mere acceptance will not
yes,
constitute an offense.
yes, my lord. That is true.
Yes.
But in this case, I want to read the evidence of the PW1. He is a corporator. The accused is a corporator. And in the defense evidence also, the cross-examination also, my lord, says that my lord is not the bribe of,
Now, why this PW1 was so conscious?
because
He has avoided that punch witness.
he's a politician, accused, a normal person.
Must be some
Eh,
reason.
Yes, my lord, it will create a doubt. It will create a doubt. It will create a doubt. That's the reason, my lord, he is such a type of person. That is the reason, my lord, is he avoided the
Was there any history, earlier incident? No.
no.
Then
Earlier instance, he is frequently demanding his 8 lakhs rupees, his the first demand amount.
why PW1 developed that suspicion? If the other witness accompany him, he may doubt. What is the basis for that?
Basic, my lord, is the nature of the politician will not receive the money the publicly.
Very freely nowadays, they are receiving it very freely.
Yeah, nowadays, in the year 2010, my lord, and he is a corporator, he should be cautious because of that reason, my lord.
ನೀವು ಇಲ್ಲೇ ಕೊಟ್ಟರು ತಗೊಳ್ತಾರೆ, ನೀವು ಕೊಟ್ರೆ ಸಾಕು.
The latest judgment of the Supreme Court under section 20, just about a month back,
ಏನು what is that?
section 20 ನಲ್ಲಿ
ಹ.
ಆಗೋಲ್ಲ ಅಂತ. Unless and until
ಇಲ್ಲ,
they-
ಏನಂತ?
it's a presumption in favor of the prosecution ಆಗಲ್ಲ ಅಂತ.
Burden is on the prosecution.
I'm sorry.
Burden is on the prosecution.
Just like 106 minute of the IPC,
Yes.
it shifts only when
Yes.
you establish or make out a case. Otherwise, no. This is the latest judgment of the Supreme Court.
That is the settled position of
Yes,
law.
that is it.
Yes. Yes.
ನಾನು ಪೂರ್ತಿ ಇನ್ನು ಏನು ಒಂದು ಹೇಳಲಿಲ್ಲ.
ಬೇಡ ನೀವು ದಯವಿಟ್ಟು.
ಅಷ್ಟೇ. I'm sorry. Grateful.
And regarding the trap panchanama. Drawing of trap panchanama, where it was drawn, in the house of the accused, in the local.
Yes, in the Lokayukta, that's also written in the trap panchanama. Kindly see the trap panchanama. Because of this reason, they shift that place.
Where the trap panchanama was written.
Yes, madam, because page number 8 in trap panchanama, internal page number 8.
ಏಟ್ ಬೇಡ ಬಿಗಿನಿಂಗ್ ನಲ್ಲೇ ಇದೆಯಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಅದು ಯಾಕೋಸ್ಕರ ಶಿಫ್ಟ್ ಮಾಡಿದ್ರು ಅಂತಾನೆ.
ಫ್ರಮ್ ದ ಬಿಗಿನಿಂಗ್.
ಆರೋಪಿತರು ಲಂಚ ಸ್ವೀಕೃತ ಇಲ್ಲಿ ಒನ್ ಮೊಮೆಂಟ್ ಇದನ್ನ ಓದ್ಬಿಡ್ತೀನಿ.
ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫಿಗೆ ನಂಗೆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್. There is no reference to drawing of panchanama in the house of the accused.
Yes, madam. Because of this reason, it's also mentioned in the
ಎಲ್ಲಿ? Page number
8. ಅದರಲ್ಲಿ. ಆರೋಪಿತರು ಲಂಚ ಸ್ವೀಕರಿಸಿದ ಆರೋಪಿತರ ವಾಸದ ಮನೆಯಲ್ಲಿ ಆರೋಪಿತರ ಕುಟುಂಬ ವರ್ಗದವರಿದ್ದರು. ಆರೋಪಿತರು ಬಿಬಿಎಂಪಿ ಸದಸ್ಯರು ಸಹ ಆಗಿರುವುದರಿಂದ ಅವರು ನೋಡಲು ಸಾರ್ವಜನಿಕರು ಹೆಚ್ಚಾಗಿ ಬಂದು ಹೋಗುವುದರಿಂದ ಈ ಸ್ಥಳವು ಟ್ರಾಪ್ ಪಂಚನಾಮ ನಡೆಸಲು ಸೂಕ್ತ ಸ್ಥಳವಲ್ಲವೆಂದು, ಬದಲಾಗಿ ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಯಲ್ಲಿ ಟ್ರಾಪ್ ಪಂಚ ನಡೆಸುವುದು ಸೂಕ್ತವೆಂದು ತನಿಖಾಧಿಕಾರಿಗಳು ಅಭಿಪ್ರಾಯಪಟ್ಟಿತ್ತು. ಇದಕ್ಕೆ ಪಂಚಗಳು ನಾವು ಸಹ ಒಪ್ಪಿದ್ದರಿಂದ ತನಿಖಾಧಿಕಾರಿಗಳು ಆರೋಪಿತರ ವಾಸದ ಮನೆಯನ್ನು ಬಿಟ್ಟು ಬೆಳಗ್ಗೆ 9:40 ಗಂಟೆಗೆ ಹೊರಟೆವು. ಆಗ ತನಿಖಾಧಿಕಾರಿ ಫಿರ್ಯಾದು ಕಟ್ಟಿದ್ದರು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಬಿಬಿಎಂಪಿ ಅಧಿಕಾರಿಗಳು ವಶಪಡಿಸಿಕೊಂಡಿದ್ದ ಸಾಮಗ್ರಿಗಳನ್ನು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಸ್ಥಳವನ್ನು ನೋಡಿಕೊಂಡು ಸಂಬಂಧಪಟ್ಟ ಬಿಬಿಎಂಪಿ ಅಧಿಕಾರಿಗಳು ಪ್ರಶ್ನಿಸಿ ಅವರ ಹೇಳಿಕೆಗಳನ್ನು ಪಡೆದುಕೊಂಡು ಬರಲು ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ರವಿಶಂಕರ್ ಅವರಿಗೆ ಸೂಚಿಸಿ ಅವರ ಜೊತೆಯಲ್ಲಿ ಫಿರ್ಯಾದಿ ಉದಯ್ ಕುಮಾರ್, ಸಾಕ್ಷಿ ಸಂದೀಪ್ ರಾವತ್, ಮತ್ತು PC ಕಳಿಸಿದರು. ನಂತರ ತನಿಖಾಧಿಕಾರಿ ಮತ್ತೊಬ್ಬ ಸಾಕ್ಷಿ ನನ್ನನ್ನು ಸಿಬ್ಬಂದಿಗಳು ಫಿರ್ಯಾದರು ಹಾಗೂ ಆರೋಪಿಯನ್ನು ಕರೆದುಕೊಂಡು ಬೆಳಗ್ಗೆ 10:30 ಗಂಟೆಗೆ ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಗೆ ತಲುಪಿ ತನಿಖಾಧಿಕಾರಿ ಕೊಠಡಿಯಲ್ಲಿ ಟ್ರಾಪ್ ವಂಚನೆಯನ್ನು ಕೈಗೊಂಡಿರುತ್ತಾರೆ.
Very shabby trap panchanamas that cannot be accepted. Recovery of the money in the house of the accused.
Yes, ma'am.
No document was written there.
According to
Having-
PW7,
yes,
it was prepared there. According to PW7, it was prepared there, IO.
Hmm.
Ravi Shankar.
This explanation given,
Witness partly there and partly in the Lokayukta office. As per
That's-
exhibit P7.
is
it was
written in the
entered in the office of the.
office of the Lokayukta.
Ah.
It's the office of the Lokayukta.
What is the sanctity that could be attached to this document?
That's why my lord, my submission is, it's a admitted fact. It's a admitted that one 313 statement and the cross examination also.
The purpose of drawing the Mahazar, sir? What is the purpose? As and when the procedure progresses, it should be noted down. It is to be recorded in the presence of the witnesses. Otherwise, there is no meaning in saying the Mahazar.
That is.
It can be written anywhere. IO
Yeah.
can write it at any time.
In a public place, my lord, on that point of time.
It is not a public place, sir. It is his residence.
It's residence, it's because the public will come and
Can you not prevent the entry of the public? It is a house, residential house. It is not as if in the highway or in the public road. No,
It's
those
a-
explanation cannot be accepted.
my submission, my lord, for this aspect, again, I am submitting DW1 evidence. Once,
Unless you probabilize the contention, you prove the demand and acceptance. I have no, this one, to look at the evidence of DW1. Accused is entitled to be silent. He need not have to take any defense. Once you discharge your primary burden, then it shifts on to the accused.
on that point of time, my lord, the explanation given by the accused.
Explanation, that is why I asked him
Explanation
to
give-
read the explanation at the first,
That one,
to know what is his case.
yes.
Hmm.
Explanation, my lord, it's in judgment itself is,
No, there is a separate detailed explanation.
yes. Page number 107 in judgment.
Exhibit P6 is the explanation.
Yes, ma'am. ವಿಷಯ ಎಲ್ ಗೋವಿಂದರಾಜ್ ಆದನನ್ನು ನನ್ನ ಸ್ನೇಹಿತ ಕಿರಣ್.
Sir, he has already read it. Even though he was not ready to read it, I asked him to read it first. He read it.
At the initial point of time itself he is admitted. And the line of cross examination also same for the, it's a loan amount.
Yes,
It's not the bribe amount.
yes.
And on that point of time, my lord, my submission is the prosecution need not be proved as the case that, my lord, he received the amount and all.
That is not the
And-
correct position of law. No. Heavy burden lies on the prosecution. If that is so, why his defense should not be believed?
Because of that reason, my lord, that's why I want to read the DW1.
See, the accused says, I had requested for a loan with the complainant.
Yes.
And that amount he had brought and gave it to me.
Yes, ma'am.
Why that should not be believed?
Because of this DW evidence, it's doubtful. That's a, he said that, my lord, Kiran, received this amount belongs to Kiran. Why he has received the amount? And Kiran is not at all hotelier. And he has no document is produced, but that, my lord, is a renovation work. And the cross-examination by the PP. One moment, kindly look into cross-examination, my lord.
Sir, no purpose would be served. I can hear your argument for an hour. It is sheer waste of time. When the prosecution has not discharged its burden, it is a futile exercise. That is why I stopped him. No purpose would be served.
So, minor discrepancy, my lord, is
No, it will go to the root of the matter, sir. Trap panchanama.
a trial court judgment, my lord, given a finding on this aspect. trap Panchanama and PW7 evidence, page number, para number 100, with regard to the exhibit, sorry, PW7, sorry, page number. Para number 153, page number 127.
That finding is questioned before this court. In appeal. On this court, it is erroneous.
It's a 128, page number 128. The special court, in the context, if the something was typed or not typed in the house of the accused, it makes no difference in the context of the case and in the light of totality of trap method exhibit P7, nor the timing stated in the 10:30 a.m. or 5 p.m. In this connection, it is also necessary to that note that if there was a split proceeding, it is necessary to mention that the prosecution has gone on record by saying that entrustment mahajar was drawn on two phases, on 16/7/2010, and second one is 17/7/2010, mentioning of the witness exhibit P7 arriving at 12:30 p.m. was projected as a serious falling to the case of the prosecution. In fact, does not take away the substance of the case, which is already established as a mahajar is not claimed to have been conducted in his presence, but PW8, in so far as a verification of currency, it was submitted that there was a deviation in the version of a PW2 and 3. The PW2 says that he compared the serial numbers in random. Learned counsel for the further submitted no
If I were
scantly
if I
could
were
be
to-
attached to the hand wash.
If I were to accept your contention,
Yes,
it will set a very dangerous proposition, unknown to the criminal justice system.
as my submission is in this aspect, if it is an IPC offense, that is so malodorous.
It makes no difference.
How does it make a difference?
Hmm?
How does it make a difference?
Because the presumption is there in IPC offense.
3, 4, 3, 4 and 5. While it is the contention of the prosecution in SC 52 of 2012 that PWs 3 to 5 in SC 105 of 2010 are arrayed as accused number 1 to 3, and it is stated that on the same date, time and place, these accused have assaulted PWs 4 and 8, who are none other than accused number 1 and 2 in SC 105 of 2010, and assaulted them, caused injuries, thereby committed the offense punishable under section so and so so and so. Learned counsel for the appellant in Criminal Appeal 1062 of 2013 contended that since the date, time and place of incident in both these cases are one and the same, the procedure as contemplated in the full bench decision of this court in the state of Karnataka by Circle Inspector of Police versus Koskiri, Nagappa and another, 2012, ILR 2012, Karnataka 509, was required to be followed. But admittedly, such procedures are not followed, and under such circumstances, the appeal is to be allowed and the accused are required to be acquitted. In Hoskiri Ningappa, the full bench of this court has considered various decisions of its various decisions as well as the decisions of the Honorable Apex Court to find out as to what was the procedure that is to be followed by the investigating officer as well as by the courts while dealing with case and counter cases. It was observed that there is no statute governing the procedure to be adopted in case and counter case or cross cases. But however, it was noted that the Honorable Apex Court has laid down the procedure for trial in such matters. In the absence of any statutory law, the law declared by the Supreme Court, which is binding on all courts in India as per Article 141 of Constitution of India, to be the good law on the point, and lay down the following good law. The reference made to the full court the division bench has referred the following questions for consideration by the larger bench. After discussing at length The larger bench answered the references as follows in para 18. Para 18 as under para 18. Next, in the present case, even though the same investigating officer investigated into both the cases, the charge sheets came to be filed on different dates. That is, the first charge sheet came to be filed on 1/3/2010, while the other one came to be filed on 31/3/2010. Even though it was tried before the same court, even though the matters were tried before the same court, they were not treated as case and counter cases. It is brought to the notice of the court that even though the prosecution has not referred to the evidence recorded in the connected matter, the trial court proceeded to refer to the evidence in the other matter to form an opinion either in favor of or against the accused. It is not in dispute that the eyewitnesses referred to in both these cases are the injured eyewitnesses who are the accused in the other case. Except the injured eyewitnesses, none of the independent witnesses have supported the case of the prosecution. There is no explanation in SC 105 of 2010 as to how and why the accused sustained injuries. Similarly is the case with SC 52 of 2012, as there is no explanation as to how and why the accused sustained injuries, which is fatal to the case of the prosecution. Under such circumstances, the accused in C-52 of 2012 were acquitted by the trial court rightly. But it has committed an error in convicting accused number 1 in SC 105 of 2010 for the offence under section 324 of IPC, and accused number 2 for the offence under section 326 of IPC. Without any basis. Without any basis. Under these circumstances, I am of the opinion that conviction of accused numbers 1 and 2 in SC 105 of 2010 was not supported by any materials, and non-following of the procedures has definitely occasioned failure of justice, and the entire proceedings and the trial got vitiated. Therefore, I am of the opinion that the appellants in Criminal Appeal 1062 of 2013 are also required to be acquitted for the offense under section 324 and 3026 of IPC. In view of the above, I am of the opinion that the Criminal Appeal 1062 of 2013 is required to be allowed by setting aside the impugned judgment of conviction and order of sentence passed by the trial court, while Criminal Appeal number 1180 of 2013 is required to be dismissed by confirming the impugned judgment of acquittal passed by the trial court. Accordingly, I answer the points. Yes.
For final hearing, serial number 15, Rahul S. Reddy, B.S. Prasad.
ಸ್ಟಾರ್ಟ್ ಅಲ್ಲ ಕನ್ಕ್ಲೂಡ್ ಮಾಡೋದು ಏಕೆ ಆಯ್ತು ರೆಡಿ ಮಾಡಿದಿರಲ್ಲ ನೀವು ಏನು ವಾಟ್ ಈಸ್ ದ ಅಫೆನ್ಸ್ ಅಷ್ಟೇ ಡಿಮಾಂಡ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅಷ್ಟೇ ಎರಡೇ ಇರುತ್ತೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಈಸ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಪ್ರೂವ್ ಡಿಮಾಂಡ್ ಅಂಡ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅಷ್ಟೇ ಅಷ್ಟೇ ಅದನ್ನು ಹೇಳಿದ್ರೆ ಆಯ್ತದೆ other one no, how this matter is connected with that, how this whether this matter is connected with that alla adralla adu naale hogidalla mattenu
Urgent tomorrow, sir.
it is already urgent tomorrow.
Serial number 15.
I already heard accused number counsel for accused number 3. Yes. 3 and 4 I think I already heard. It is for your arguments. Accused number 1. ಆಯ್ತು ಇದು ಯಾವ್ದಿದು
Serial number 15, Rahul S. Reddy.
Yes. It is for final hearing finally. Have you filed your wakalat? When? When you filed it? ಹಾಕಿದಾರ ನೋಡಿ already filed? Go ahead with the matter. Morning ಕರೆದ್ರೆ ಪಾಸ್ ಓವರ್ ಅಂತೀರಿ, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಎಂಗೇಜ್ಡ್ ಇನ್ ದಿ ಅದರ್ ಕೋರ್ಟ್ ಅಂತೀರಿ, ಮಧ್ಯಾಹ್ನ ಕರೆದ್ರೆ he was ready in the morning, now he is held up ಅಂತೀರಿ. ಏನು ಆಫೆನ್ಸ್ ಏನು? ಓಕೆ, ಲೋಕಾಯುಕ್ತನ ACB ನ ಲೋಕಾಯುಕ್ತ. Obviously. Counsel for the appellant again prays for time. Order sheet dated 6/6/2025 reads as under. In spite of that, the counsel for the appellant is not ready to address the argument. I do not find any reason to adjourn. However, to afford one more opportunity this time.
Serial number 16, J. Kittu.
No further adjournment. Yes. Yura. Okay. Yes, yes. Only under 376? Convicted only for 376?
No, for other offences, but the maximum offences.
I too, which are the other offences?
Other offences are 366, 323, 506, 76. The judgment at page number 81 of the paper book, the data page number 1.
1 minute, sir. 1 minute, sir.
Yes.
Systematically, you have to go.
Yes. Under one.
Astena.
That's what I request to go to page number 91. First page. The date of offense was 30/11/2009.
30?
30/11/2009.
Ah,
The FIR was issued on 1/12/2009.
yes.
Lord, the accused petitioner was arrested on 4/12/2009.
Hmm.
4/12/2009.
Since then he is in custody.
He was in custody. So he was convicted on 26/7/2011.
No, he is in custody since.
In fact, what you said, because I have prepared the system on next week.
Good.
This is the prosecution meeting is examined by the prosecution.
Have you confirmed that he is still in custody?
This is full pay. Once the accused was produced on 18/7/2016 before this post, then only the advocate was permitted to retire. Then because PD was appointed. Somehow only I came to know on June 2020 or 25 that I was appointed.
Okay. So I'll.
Already he has undergone this.
Okay. Yes, togoli. For
report on if he is not involved in any other cases, if he is still in this case,
yes.
they are just developed and.
Okay. The accused in SC 430 of 2010 on the file of the fast track bracket money sessions judge 5 Bangalore City is impugning the judgment of conviction and order of sentence dated 26 July 2011, convicting and sentencing him for the offense punishable under section so and so so and so. The facts of the case of the prosecution is that on 30/11/2009, at about case of the prosecution is that on 30/11/2009 at about 12:30 p.m. CW 6 and 7 yaru. Who are they? CW 6 and 7. Injured yaru. Victim PW5 and the other two CW 6 and 7 caused hurt anta ideyala yarigu PW 6 CW6 PW6. Other one is not examined. PW so and so and CW7. The learned magistrate took cognizance of the offence and committed the matter to the Sessions Court. The accused appeared before the trial court and pleaded not guilty. He claims to be tried. The prosecution examined PWs 1 to 19, got marked exhibit P1 to 26, identified MS 1 to 7. The accused denied all the incriminating materials available on record in his statement under 313 of CRPC, but has not led any evidence in support of his defense. The trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of the accused for all the above offences and accordingly sentenced him so and so, as stated above. Being aggrieved by the same, the accused is before this court. Learned amicus curiae for the appellant and learned additional SPP for respondent. I read the materials, point for consideration, I answer to the above point. And the negative for the following reasons. Serious allegations are made against the accused that he had committed the who also supported the case and corroborated the contention taken by the prosecution. Medical report ಯಾವುದು? Forensic medical report. 24 P1 ಅದು clinical exhibit P1. Exhibit P1 is the medical investigation report issued by PW1, the doctor who examined the victim girl. With a history that the accused had kidnapped her, kidnapped and assaulted her. Is there any final report? Exhibit. ಇರಬೇಕಲ್ಲ ಅಲ್ಲೆಲ್ಲ 24. Exhibit P24 is the FSL report, is the forensic medicine, the report from forensic medicine, Victoria Hospital. They are pertaining to the accused. Hyman was absent. From the materials on record, it is found that the accused is taking advantage of the minority of the victim girl, kidnapped her and committed sexual assault. The accused has not taken any specific defense. He has only denied the incriminating materials available on record. Under such circumstances, it is to be held that the prosecution is successful in proving the guilt of the accused beyond reasonable doubt. Imprisonment of 10 years for the offence punishable under section 376 of IPC. He has already served the sentence. Under such circumstances, he pays for setting aside the fine amount imposed by the trial court and to order for release of the accused in the interest of justice. Next, the impugned judgment discloses that the accused was apprehended on 4/12/2009 and he was in custody till the judgment of conviction and order of sentence. Even after referring this appeal, it is found that the accused is in custody. He has already spent extortion money, so and so, in prison, as against the conviction of 10 years for the offence punishable under section 376 of IPC. Even though he is sentenced to undergo imprisonment for the offence under section 323, 506 of 323 and 506 of IPC, the trial court ordered that all the sentences regarding payment of fine by the accused. Accordingly, I answer the above point partly in the affirmative and proceed to pass the following. Appeal is allowed in part. The judgment of conviction dated so and so, passed in so and so, is confirmed. The order of sentence passed by the trial court imposing or ordering the accused to undergo imprisonment is also confirmed. However, the order to pay fine for the offence punishable under section 323, 506 and 376 are set aside. Since it is stated that the accused is in custody since 4/12/2009, the Chief Superintendent of Prisons said, where is central prison now? Yes.
We have got the report from the, we still interested in this case.
Since the accused is in judicial custody since 4/12/2009 and he is now lodged in the central prison, Parapanagrahara, that order is set aside. Paying the fine amount is set aside. 5,000. Nothing. The disposed of. The registry is directed to communicate this order to the Chief Superintendent so and so for information. Communicate the order. Order portion ಹಾಕಿ ಅದರಲ್ಲೂ ಬರುತ್ತಲ್ಲ, ಆಪರೇಟಿವ್ portion ಅಲ್ಲೇ ಇದೆ. Allowed in part. Fine amount is set aside. Yes. Fixed at 5,000. ಎಷ್ಟು 10,000 ಮಾಡ್ತಾರೆ? 10,000 ಮಾಡಿ. ಇದೇನು 10,000 ಮಾಡಿ. Fixed at 10,000. Yes. Next. Other matters will be repeated tomorrow. Tomorrow ಮತ್ತೆ ಯಾವುದು ಆಗಲ್ಲ ನೋಡಿ ಯಾವಾಗ ಹಾಕ್ತೀರಿ. ಆಯ್ತು.
Matter pertaining to Kalburgi bench, first over matter, serial number 1, Ganesh Subhash Chandra.
the portion of the order sheet relied on by the appellant is legible. And the counsel submits that he is not relying on the other portions of the order sheet. Same is accepted. Of his objection in that regard is ignored. Issue notice. ಇದು 1 and 2 ನಲ್ಲಿ ಸೇಮ್ 3 ನಲ್ಲಿ ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಇದೆಯಲ್ಲ ನೋಟಿಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್ yes what is
serial number 19, but there is a provision of
yes what is
serial number 19, but there is a provision of the SC/ST Act is invoked. Notice to the victim may be ordered.
victim is a party,
Not a party in the appeal. Notice has to go if not your lordship.
you have to file an application. ಹಾಕಿ 2013 ಇಂದ ಇವತ್ತಿನವರೆಗೂ
ಇಲ್ಲ,
ಏನು
ಅವಾಗ ಇರ್ಲಿಲ್ಲ ಅದು ಪ್ರಾಬ್ಲಮ್.
ಫೈನಲ್ ಇಂತೆಲ್ಲ ಆದ್ಮೇಲೆ ಈಗ ಒಂದೊಂದೇ ಹುಡುಕ್ತಾ ಇದ್ರಿ
ಇಲ್ಲ I am ready to go on with the matter. ಅಲ್ಲ, I am ready to go on with the matter, my lord.
otherwise you file an application.
I'll make an application.
I will not take that burden on myself.
I'll make an application. Next week, my lord.
ಆಯ್ತಾ?
Next week, my lord. I'll make an application.
ನೋಡೋಣ ಕೊಡ್ತಾರೆ.
Please.